Welcome everybody to our webinar regarding the new FCC one-to-one consent ruling. I'm Eric Tejeda, Vice President of Marketing for Possible Now. And joining me today is Kevin Mayfield, Manager of Marketing Compliance with our sister company, CompliancePoint. Today, for the agenda, I will do a quick review of the business problem that everybody is facing. Kevin will then jump in and go into the detail of the regulatory overview, and I'll come back and share some sample workflows and approaches we've seen in the marketplace that you can take as warranted for your particular situation moving forward. And at the end, we'll close with a Q&A, but certainly feel free to send us questions at any time during the presentation through chat. So as we look at the business problem, in January of next year, the FCC one-to-one consent rule goes into effect. And this rule basically applies to two audiences: performance marketers and lead aggregators. That's one audience. So organizations that professionally collect leads and sell them to businesses. The other audience is it applies to brands. So particularly companies that have multiple brands under their umbrella, and they share those leads with their affiliates. It impacts them as well. So for example, we have a client that does residential services. They have multiple brands that offer plumbing, gutter services, electrical, and many other services. Until now, they only had to collect one consent and they could share those across their brands. But after January, they'll need to capture consent for each of those unique brands that they want to share that lead with. Further, a few weeks ago, we had a client that was one of our contacts at a client that has since moved companies, and they're in the security services industry. And he called last week and said that they've got a big consent problem, because when he got there, he said there weren't a lot of people that truly understood consent well. And now they're really struggling with this new one-to-one consent ruling and how it's going to fully impact their affiliate marketing efforts. So marketers, bottom line, that's the landscape they're living in right now, and they need solutions. You need solutions. I need a solution that provide dynamic consent capture. That's the bottom line. You need to be able to navigate that landscape in a way that minimizes the number of custom forms and configurations, so that you can focus on the lead generation process instead of capturing consent. And you also want to be able to maximize adoption and customer experience, because the number of leads are necessarily going to decrease now that you've got more restrictions on the process from the FCC. So you'll need a platform ultimately that will evolve as regulations change, because I can assure you of one thing: this isn't the last change. So that's kind of the business problem that we're going to deal with today. And with that introduction, Kevin, I'll turn it over to you and let you walk everybody through the regulation.
Thanks, Eric. Many of you may have heard by now that the FCC has coined this as closing the lead generator loophole. And what the FCC has said is that if you're a lead generator and you are going to be generating leads, that your lead buyers will be using an automatic telephone dialing system, that is an ATDS, or pre-recorded artificial voice, that this rule is going to apply. And each seller must have their own prior express written consent on a one-to-one basis. And the TCPA defines a seller as the person or entity on whose behalf a telephone call or message is initiated for the purpose of encouraging the purchase of goods or services. So it's important to understand that this is going to affect the sellers if the sellers are making the calls. Consent is going to be limited to calls and texts for products and services that are logically and topically related. And so we'll talk about that a little bit more. And this is going to apply to both robocalls and robotexts. So robocalls being live agent calls with an ATDS or any pre-recorded messages, or any in robotext would just be defined as any text message sent with an ATDS. So this is really a major overhaul for the lead gen industry. I think we've all seen the consumer shopping sites, comparisons to shopping sites where, consumers are opting in to hear from multiple sellers on one form. And so this is going to be a major impact for the lead gen industry as a whole. And as Eric mentioned, this is effective January 27th of 2025. Just to kind of recap where it all started, going back all the way to 2012, there was an FCC order that required prior express written consent for telemarketing calls using an ATDS or pre-recorded voice, and to any landlines using an artificial or pre-recorded voice. And that prior express written consent must identify the seller who's going to be utilizing the consent. They got to identify the consumer's phone number. The consumer must have some sort of affirmative agreement in the consent language, such as I agree or I consent. It needs to be clear and conspicuous. And the FTC has their own set of .com disclosures. The FCC does not define what clear and conspicuous mean, but there's plenty of references to clear and conspicuous disclosures in the Federal Trade Commission's .com disclosures, and there's no reason for us to think that the FCC is going to be have a different opinion on any of that than the FTC does. So they're going to need to clearly and conspicuously authorize the seller to engage in advertising or telemarketing. That got to clearly and conspicuously disclose that the calls will be made using automated technology, and that the consumer is not required to provide consent as a condition of purchasing the goods or services. And that signature needs to be in written form. Probably a different discussion for a different day, but there have been some recent court cases around the e-sign Act and what constitutes written signatures. For the purposes of our webinar today, we're going to assume that a standard web form constitutes written consent, but there's certainly more to come on that topic as a whole. So how we got here. So like I mentioned before, we've all seen the sites. I go on, I'm shopping for windows for my new home. I fill out the form, the consent disclosure there. It says that I'm agreeing to calls and texts from marketing partners, and I click on the marketing partners hyperlink, and there's 1,000 different companies listed on that page. Some of those are going to be window companies that might call me, but they also might be homeowners insurance companies, roofing companies, siding companies. They know I'm a homeowner. I'm looking for windows. So, they know that they can then sell that lead, maybe for not as quite a lucrative as they might be able to sell it to a window company, for example, but they could sell it to a roofing company as well, because I've opted in to hearing from that roofing company. I'm using air quotes around opted in, of course. So that's kind of how we got into this situation. And, the calls, that consumers were just inundated with calls and texts related to, one form submission. And, some time ago now, the FTC had some enforcement actions against for-profit education companies when I was completing a web form for a job site, for example. And those leads were then getting sold to for-profit education companies. But now it's the FCC's turn. So let's talk a little bit about the FCC's concerns that brought about this rule. The big one being that, consumers were really just bombarded with, texts and calls from a single lead submission. And there's a lot of reference by these federal agencies to what the reasonable consumer would understand, right? And it's just a fact that a reasonable consumer does not understand that by clicking submit, that they are agreeing to, thousands to hear from thousands of companies via automated calls and pre-recorded messages. They just don't, that's just not something that registers with them. And they certainly don't understand that if they fill out, on a job seeking form, that they're going to get called by for-profit education companies, and if they're looking for windows, that they're going to get called about siding and roofs and HVAC systems and no telling what else. So, the consumers really lack the ability to control the scope of their consent, right? They couldn't say, hey, I only want to hear from window companies. And that's what this rule is going to solve for them. And we all receive the text messages. It's hard to tell what's real and what's not these days. And if I fill out a form submission about Windows and I get a text message about Windows, then that makes sense, right? But if I start getting text messages about roofing and siding, then it's hard to know what's real and what's not. So the FCC was looking to solve a little bit of that in this as well. So talking a little bit more about the ruling, you're going to need one-to-one consent for all automated calls and text messages. That prior express written consent must be for a single seller at a time. And the calls and texts must be logically and topically related to the interaction or website where consent is provided. So there's going to be no more, Windows website and getting calls about roofing simply because I'm interested in Windows. Consent records are going to be maintained by the seller. So if I'm a lead buyer, I'm an insurance company, I'm the seller in that situation. It's going to be on me to maintain those consent records, even though the consent records may have initially been gained by the lead generator. And text messages have now been codified into the do not call rules. So that's all official. The FCC has had commentary for years that texts are calls and calls are texts, but they've now made it official and said that text messages are subject to these same rules as calls. Talk about some FCC commentary and what they said during this ruling. We believe adopting a revised rule is the best way to make unequivocally clear that one-to-one consent is required under the TCPA and to stop large numbers of robocalls and robotexts from many different entities based on a single consumer consent. So that's kind of going back to what I was saying earlier about the reasonable consumer just doesn't understand what they're agreeing to. The consumer's consent is not transferable or subject to sale to another caller. So if I consent to hear from Allstate Insurance, that is not transferable to State Farm, for example, to then call me. Nothing in our rule restricts the ability of businesses, including small businesses, from relying on leads generated by third-party lead generators. So they're saying that lead generation is not illegal, right? But you're not going to be able to do it in the manner in which it has been done in the past. Commenters failed to articulate why, under their current lead generator processes, a consumer should be deprived of the opportunity to consent to robocalls and robotexts after the match between the consumer and seller is made. So what they're saying is that those that were opposed to this new one-to-one consent rule tried their best to make an argument why it should stay status quo. but were unable to satisfy the FCC in that regard. All right, so let's talk a little bit about what we think are going to be some options as far as what's going to be allowed and what's not going to be allowed. I think the first bullet there, the separate consent disclosures for each seller on a page, accompanied by unchecked boxes next to them. I think that's pretty much a no-brainer. I think that meets the spirit of what the FCC is trying to do here. And I think Eric's going to show you some examples of what we're talking about there a little bit later. The second option being a single consent disclosure followed by a list of sellers where with unchecked boxes where the consumer can choose which ones they want to hear from. Now, we reached out to outside counsel about this second bullet, and they feel like displaying multiple sellers with a single disclosure option will likely be allowed. However, it's not specifically called out in the regulation, and in that instance, you would not be naming the seller within the disclosure itself. So, it is a little bit of a gray area that will probably be clarified either through regulatory commentary or through the court system. But Eric's going to show you what some examples of what we mean by that as well. But we feel like, in the spirit of the law, that will likely be okay. The other one, again, fairly no-brainer, a click-through link to the seller that goes directly to their landing page where you're going to be able to give that one-to-one consent to that seller. And the last thing is logically and topically associated, right? So the FCC purposefully did not define what logically and topically associated means. But I think it's safe to assume that, you've got to think like, what would any reasonable consumer expect? So if I'm on a comparison shopping site for internet, for example, and I get a call from that internet provider and we talk about internet, and then they want to then transition that call into cable TV services. So we think that that's likely to be okay. Again, the FCC didn't call that out specifically and say that that was okay, but it seems like certainly in the spirit of the rule, a reasonable consumer would expect something like that to happen. As far as what's no longer allowed, the old traditional hyperlinked list of sellers where you're listing multiple sellers behind a hyperlink. You're requiring consumers to consent to a long list of sellers within a single disclosure statement with no ability to choose which ones they want to hear from. And then passing consumer consent to additional sellers downstream. So, reselling of aged leads and things of that nature, where there's going to be calls from people that the consumer is not expecting to hear from. And the FCC did call out what's not allowed as far as when it comes to logically and topically associated. And they gave an example of, I'm a consumer and I'm shopping for a car loan, and now I'm going to start getting calls about loan consolidation. So that would be something that would not be allowed, that they did not deem that as logically and topically related.
Thanks, Kevin, for the regulatory overview. Now let's look at the lead flow process as well. In this flow chart, you'll see there, really on the top left, in the first components is the lead flow itself, and the website is asking profile questions and quality questions, and so maybe they're asking what your name is. Eric Tejeda, live in Norcross, Georgia, drives an SUV, and has car and auto insurance policies. All of that data is being captured for a reason, and there's lots of decisioning that's happening on the back end that's very sophisticated for these lead buyers. So, for example, carriers, which states do they work in? Some have Some have backed out of Florida and California, for example. So that's got to be part of the lead uh, capture logic, because you're only going to show the carriers for a state that they work in. Or if you've got an exclusive lead arrangement with a carrier for, let's say, 50,000 leads, and you've only sold them 40,000 so far, then you may want to present that carrier first. So all of that logic remains with the brand or the lead aggregator that's creating this process. Um, so so now imagine they're getting through this process, and they get to the point of providing their phone number. Now is when the lead aggregator needs to capture consent based on the brands that they plan to share the lead with. And we're able to then integrate, and you see now it goes down in this flow chart. And this is where via API, they can make a call to our platform in this example, and so that the lead seller or the brand can retrieve and display dynamically the consent disclosures that are appropriate. Number two, capture the consent. And number three, maintain all consent records for audit purposes down the road. So that's what's happening behind the scenes at that critical juncture for capturing consent. Then when that's all taken care of, they're right back to their lead flow process. And if they ask more questions, so be it. But they continue to do that. The other thing that can happen here, leads that are going to be integrated with, probably any number of providers. So it's important to attach customer IDs, trusted forms, or tokens to really close the chain of custody on the consent experience. So those are all things that are super important. But the big takeaway here in this workflow is that the lead aggregator, performance marketer, or brand is fully in control of their lead process and experience, and integrating the consent process is done simply just through API integration. So it's seamless. So now that you kind of have an understanding of how Possible Now would come alongside and help with the consent capture component, let's walk through a few different approaches that we've seen in the marketplace. So imagine that I'm in a lead flow and I've answered all the questions about myself. I finally get to the point of providing my contact information, and all the behind the scenes calculations are taking place. And it determines that this should be an exclusive lead flow. So we want to go sell this lead to Progressive. So I'm going to present the Progressive as a single option with the disclosure text that goes right to them. Simple enough. The next example is a single consent for multiple brands. Here we're having a single consent disclosure that all the brands or carriers share. So it's the same disclosure language. And the prospect can then go select which carriers they want to quote from. Again, the brand or the lead aggregator determines which of these options they want to present, of the potentially hundreds that they manage. Frankly, the most likely opportunity to use a single disclosure language like this example is with a house of brands, where one company has multiple brands. The legal department's going to get together and say, yeah, this disclosure language works for us. That to me is probably more practical than a lead aggregator working with a number of different companies and trying to get everybody to agree to the same disclosure language. But if you can do that, that's great. But that's an example. So one consent language at the top in this example, and then you select the brands that you are willing to receive a phone call from or a text. The next one is multiple consents for multiple brands. So very much the same, but in this example, which is what I would expect to be more common. We've got multiple consents associated with multiple brands. So you see there that under each brand, the disclosure or a consent language is unique, and it's part of the box for that brand. So that when you click on that, you technically would, those The disclosure language would vary to a degree, but you can either read that or not. Most people don't, but that's the way that would operate. And then finally, the other thing we're seeing from lead providers is that they're thinking about adoption and best practices, and they're doing A/B testing and saying, okay, based on these new rules, how is that going to impact our lead conversion once we start providing more consent options? And how are we going to do it to achieve desired outcomes? So one of the ideas that we've heard is that when a prospect selects one provider, then they may pop up another window and give them the opportunity to select others on a second go around. And just for example, here it's like, did you know that shopping across multiple providers can help result in 30% more savings? So it's just another way that they can generate leads for additional opportunities. And that's the kind of things people are thinking through now, because it is going to most likely negatively impact the volume of leads, just because everybody's got to get one-to-one consent. So, okay, well, that's the end of our formal comments. So we're going to go to Q&A. So feel free, if you haven't done so already and you've got a question, to send those to us via chat. And just so you know, we will send the PowerPoint or this presentation, the webinar, out to all of you after the webinar is done. So while we're waiting for the questions to be submitted, I will say that if for any of our clients that are on the call that are on My Preferences 3.0, you do have access to all the required consent functionality in order to meet or stay in compliance with this regulation. Just simply reach out to your CSM if you need help configuring that within your application, and you'll be all set. So here's a couple of quick questions. So you mentioned that there could be an issue with obtaining written consent on a web lead form. Can you elaborate on that a little bit?
Yeah, sure. So there was a fairly recent case in a district court in Maryland, I believe it was, Bradley versus dentalplans.com, I believe the name of the case was. And basically the court ruled that, we'll just back up quickly, people have been getting what they deemed as written consent over the phone for years, right? They read the disclosure, they're on a recorded line, the consumer says yes, and the FCC had basically said that, yeah, that constitutes written consent under the e-Sign Act. Well, what this court found was that there's specific disclosures that come with e-signatures under the e-Sign Act. And so without making those disclosures, then you're not really complying with the e-Sign Act, and so therefore the consent can't be written. So, and that's not really limited to just being over the phone. It can affect these web forms as well. If you're not disclosing what needs to be disclosed under the e-Sign Act, then you could find yourself in a situation where a court deems that as not valid written consent. I'll say that we haven't seen a lot of movement in that area. A lot of companies have been just business as usual in that regard, and kind of a wait and see approach. But that court case is out there, and I'm pretty sure it's being appealed at the moment.
Thanks, Kevin. So the part two of that, and I'll go ahead and answer this one, is in general, how long is consent good for? And it's good until the consent is revoked. So you're free as an organization to set limits if you'd like to, but from a regulatory standpoint, it's good to go until they revoke it. Have you heard of, so here's the next question, have you heard of any way to gain this consent on TV or leads? Also, if there's not an ATDS used in the sales process, is this one-to-one consent required?
So I'll take the second part of that first. I guess the argument I would make there is that, nobody thinks that they're using an ATDS today. right? I mean, by definition, nobody thinks they're using a system that has the capacity to randomly or sequentially generate numbers and so on and so forth. But everybody wants that express written consent disclosure language in there as if they are using an ATDS to prevent someone from claiming you're using an ATDS, right? Because you don't have to be using an ATDS for someone to claim that you're using an ATDS, and then you're stuck having to defend yourself. So technically speaking, you're correct. If it's not an ATDS, then none of this even applies, or pre-recorded message. None of this even applies, but everybody wants that protection of having that language in there. As for TV leads, I would think that you're trying to generate an inbound call from a TV lead. If I see your ad on TV, you're wanting me to take some sort of action to call in, what have you, in which case you're going to be getting then the consent verbally over the phone, which kind of goes back to our last question about the e-sign act and that one case that's out there and how that could be problematic.
Great. Okay, so did any of the timelines change, i.e., 90 days for a new lead or 120 days for an existing contact who purchased?
I think what you're referring to there is the exemption periods for do not call rules. So on an inquiry, person calls inbound, they're asking me about my internet service, and I tell them about it, but they're interested, but they don't buy, right? You're going to have a 90 days from a DNC perspective to call that person back without needing to scrub that against the national list, for example. 120 days, that I don't think there's a 120-day limit. There is an 18-month limit from a DNC perspective on a previous customer. But what we're talking about here with the consent is, that basically makes that exemption period good forever until the person tells you to stop.
So the next one, the ruling. This ruling is on a go-forward basis, correct? If so, if a company obtained consent prior to the ruling, it can still be used to contact consumers. Is that correct? And this is not necessarily via a lead generator.
Right. So, the FCC has coined the rule as the lead. They're closing the lead generator loophole. I don't think this ruling addresses what you're talking about there specifically, but the spirit of this rule is that they're trying to prevent consumers from getting a barrage of calls from a number of different sellers. Now, if you as a seller already have direct one-to-one consent with that consumer, then that's not what we're really talking about here, and that consent would remain good.
All right, great. So it looks like we've got two more. Can a lead generator be a seller in this instance to make the initial phone call?
Yeah, so that's a good question. I think that unfortunately that one's probably going to get played out in the courts, or they're going to need some additional commentary around the rule. I think that in the spirit of it, a lead generator cannot be a seller. Now, some lead generators are going to argue that, hey, we're providing a service. We're matching this consumer to multiple different insurance companies or home security companies, for example. But the argument starts to fall apart when you find out that the lead generator is making those matches based on who's going to pay the most for the lead. I do have one other lead gen client that they work on strictly a rotation basis. So, if you're in the Atlanta area, they're going to give it to company A this go round, and company B next go round, company C, and so forth until it comes back to company A. I think that scenario probably makes it a little easier to make that argument that they're providing that service. But that one probably is a little bit of a gray area and is going to have to play itself out.
All right. It looks like this is the last one, or do we have a new one? Okay. So this one is for smaller companies. Is there a site where we can get verbiage to use on the double opt-in to meet these new requirements? This is for our company lead generation. We do not sell or share leads.
So I mean, if you're not calling with an ATDS and you're not sending pre-recorded messages, really then all you're worried about is do not call rules, right? So as long as you have a disclosure on there that makes it clear and conspicuous to the person that they are opting into hearing from you for marketing calls, you wouldn't have to have any special language in regards to ATDS and otherwise. Now, if you want that protection of using automated technology or pre-recorded messages, then you would have to include that. As far as a site where you can go to get verbiage, there's a lot of companies out there that do a good job of it. You might just have to look around a little bit.
Yeah, there's plenty of examples. And then ultimately, though, you want to probably have some inside counsel agree that that's a good way to go for your specific needs, right?
Yeah.
Okay, so this is the last one, Kevin. Does the ruling go beyond the comparison website scenario? For example, the consumer goes directly on a product website page, completes the TCPA consent process, but it may have two entities topically related as education providers.
Right, so that's a good question. I don't think that you're going to find that called out in the ruling specifically. They're really targeting comparison websites. I think that certainly you could make the argument that if I'm on an education company's website, the site is branded as that, and you have a sister company and what have you, that you also want to gain consent from, that if you clearly and conspicuously called that out, that you could make the argument that would work. I still think it's probably a safer bet, though, to have the two unchecked boxes like Eric was showing earlier and let them choose if they want to hear from both companies or not.
All right. So Kevin, I teased you with saying the last one, that was the last question, but we've got one more. Is it 10 days or 10 business days to honor a DNC request?
Yeah. Right now it's 30 days, and I'll have to look, but I'm almost certain it's 10 business days. We can definitely follow up with you on that specific question, though.
All right, great. Looks like that's everything. So thank you, everybody, for attending today, and feel free to reach out to us if you've got further questions. Just shoot us an email, and we'd be happy to get back to you on that if something comes to mind. And with that, until next time, have a great day.